Must an executor give you a copy of the last will and testament? Hi, I'm Guy DiMartino. I'm a Northwest Indiana probate and estate planning lawyer. And today I'd like to answer that question for you because it was recently asked of me. And so the thing in the law is that words and terms matter. So the question, does the executor have to give you a copy of the will, means a number of things. If the person who wrote the will is still alive, you're not entitled to a copy of the will, whether you're in the will or not. But when you use the term executor, that means somebody who was already appointed by the court to be the executor or personal representative. If that's the case, the will should have been filed in the court and it becomes a public record. And if you are a beneficiary under the will, you're entitled to a copy of the will. Or you can go to the clerk of court and get a copy of the will. But if the person who wrote the will, the testator, is still alive, you're not entitled to a copy of the will. The will doesn't even come into play until somebody dies and there is assets that have to go through probate. The will only comes into play if there's an asset that is titled only in the decedent's name at the time of death. If there are bank accounts with beneficiaries, doesn't go to probate, doesn't go through the will. If there's a car with a transfer on death, doesn't go to probate. If there's life insurance policies with beneficiaries, doesn't go to probate. If there's a transfer on death deed, doesn't go to probate. No will. The only thing that matters is a piece of property that is titled in the decedent's name only at the time of death. So are you entitled to a copy of the will? Yes, if the matter has to go to probate, and if you are a named beneficiary in the will. And if it has to go to probate, it's in the public record. You're free to get it. Any questions? You can always reach out to me. I am Guy DiMartino. Have yourself a great day.